Mr. Mouinudden was born in East Bengal, which then formed part of Pakistan, but is now Bangladesh. In 1971, Bangladesh became independent from Pakistan following a war of independence. Many atrocities were committed during the war, including the abduction and murder of 18 prominent intellectuals. Mr. Mouinudden left Bangladesh in December 1971 after he became aware of allegations that he had been a member of a militia said to be responsible for the intellectuals' deaths. He denies having been involved in any violence. Mr. Mouinudden arrived in the United Kingdom in 1973 and became a British citizen in 1984. He has held a number of prominent public and charitable positions in British society. In 2013, Mr. Mouinudden was tried and convicted in his absence by the Bangladesh International Crimes Tribunal, or ICT, for war crimes, namely the murder of 18 intellectuals. He was sentenced to death. The ICT was widely criticized internationally, for example by the United Nations, foreign governments, and human rights organizations, for failing to respect minimum fair trial guarantees and for lacking judicial independence. Mr. Mouinudden's conviction was reported by the media in the United Kingdom. The media reports noted the criticisms of the ICT and that Mr. Mouinudden denied the charges against him and maintained that the trial was unfair and politically motivated. In 2019, the Home Office published a report entitled Challenging Hateful Extremism. In a section entitled What Extremism Looks Like in England and Wales, the report stated that links between those responsible for the violence in Bangladesh in 1971 and community leadership in East London were well established, and referred to Mr. Mouinudden's ICT conviction. Mr. Mouinudden then issued proceedings against the Home Secretary for libel. At a preliminary hearing, the High Court decided that the words used in the report meant that Mr. Mouinudden was one of those responsible for war crimes committed during a 1971 War of Independence in South Asia and has committed crimes against humanity during a 1971 War of Independence in South Asia. The High Court held that these allegations were defamatory. The Home Secretary then applied to have Mr. Mouinudden's claim struck out without any trial of the facts on the basis that it was an abuse of the court's process. The High Court agreed to strike out the claim, and its decision was upheld by a majority of the Court of Appeal. Mr. Mouinudden now appeals to the Supreme Court. The Supreme Court unanimously allows his appeal. The Home Secretary relies on the court's inherent power to prevent its process from being misused in a way which would be manifestly unfair to one or more of the parties, or would otherwise bring the administration of justice into disrepute. The Home Secretary argues that Mr. Mouinudden's claim is an abuse of process because it falls within two well-established categories of abusive proceedings. They're known as Hunter abuse and Jamil abuse, after the names of the legal cases in which they became established. Hunter abuse arises where a claimant uses proceedings to attack a decision made in earlier proceedings. A claimant who wishes to challenge a decision made against him should normally do so by appealing that decision. The court should not generally permit him to pursue new proceedings in order to re-litigate matters which he had a full opportunity to contest in the earlier proceedings. Allowing this would give rise to a risk that the decisions in the two sets of proceedings would be inconsistent, bringing the administration of justice into disrepute. However, not every challenge to earlier proceedings will amount to Hunter abuse. The Hunter principle only applies where the earlier proceedings were fair and where they provided the claimant with a full opportunity to contest the court's decision. Accordingly, a challenge to an earlier foreign criminal conviction will not necessarily amount to an abuse of process, particularly where there are concerns that the accused did not have a fair opportunity to put his case and to meet the case made against him. In cases of this kind, the court must judge the procedural quality of the earlier foreign proceedings. Applying this to the present case, Mr. Mouinudden's claim against the Home Secretary cannot amount to Hunter abuse because he did not have a full opportunity to contest the ICT's decision to convict him. He was tried in his absence and was unable to give instructions to counsel appointed to represent him. He could not appear at his trial as he risked execution and was in fact sentenced to death. There was no real possibility of an appeal against the conviction. It follows that the Hunter principle does not apply. The Home Secretary also argues that it's unfair for Mr. Mouinudden to bring these proceedings because the events in question were so long ago that it may be difficult for the Home Secretary to prove that the allegations which had been made against Mr. Mouinudden were true. This argument cannot be accepted. Mr. Mouinudden's claim was issued promptly after the report was published. He is not responsible for any difficulties the Home Secretary may face in proving the truth of the allegations, which are in any event a matter of speculation. If the Home Secretary will find it difficult to substantiate the allegations made about murders committed more than 50 years ago, that should have been considered before the allegations were published in the report. That leaves the question of Jamil abuse. Defamation proceedings will be struck out on that basis if they do not serve the legitimate purpose of protecting the claimant's reputation because the damage suffered by the claimant is so trivial that it does not pass a minimum threshold of seriousness. Mr. Mouinudden's claim against the Home Secretary is not abusive in the Jamil sense. The allegations that he is responsible for war crimes and crimes against humanity are plainly very serious. He is offering to prove that the allegations published in the report have caused more than minimal damage to his reputation in the United Kingdom. The majority of the Court of Appeal considered that Mr. Mouinudden's claim was of little value, but they were mistaken in reaching that conclusion. First, they considered that the report could not have damaged his reputation because even before the report was published, his reputation was that of someone involved in the murder of the intellectuals. But Mr. Mouinudden maintains that he was a respected member of British society. Whether that is so is a matter to be decided at trial. Furthermore, the majority of the Court of Appeal treated the fact that Mr. Mouinudden had been convicted by the ICT and the fact that that conviction had been reported in the media as conclusive evidence of Mr. Mouinudden's bad reputation. But that approach was contrary to established legal principles, as explained in the judgment of this court. The majority of the Court of Appeal also considered that Mr. Mouinudden's claim against the Home Secretary could not possibly result in the vindication of his reputation, because people who did not accept the result would point to the absence of relevant witnesses and evidence. This court disagrees. It's possible in any litigation that there may be people who will not accept the result, but that is not a principled reason for denying a party the right to bring his claim to trial. Mr. Mouinudden has a legitimate interest in protecting his reputation against the extremely serious allegations the Home Office has made against him. If he succeeds in these proceedings, it's reasonable to expect that that will be a major vindication of his reputation. The court therefore concludes that Mr. Mouinudden's claim should not have been struck out and that he should be permitted to pursue it at trial. The court will now adjourn.